I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today we are courtroom hopping back once again into the courtroom of Judge Elias Sabri for Mr. Carnell McCreary's fourth appearance. If you don't know who Mr. Carnell McCreary is, or if you don't remember who he is, I want you to check out this clip.
All due respect, like I said, I don't have anything personal against this court or anything. I just request that this court adhere to the supremacy clause of the U.S. Constitution and hold that these state statutes in which they have me charged with are constitutional based on the U.S. Supreme Court. And what is the case? The Cheney versus Winnebago Department of Social Services, there was a young child whom the mother relays that the father was beating the child and the child died. The mother sued all the way to the U.S. Supreme Court. And the U.S. Supreme Court held that no matter how bad or gruesome that this case was, when it concerned the case, that the states have no duty to protect citizens from other citizens. Anything that compels performance, there has to be a contract.
So as you can see, Mr. Creary definitely has a lot with him, definitely has his super sovereign citizen head on. And if you have not seen those proceedings, you can find the links to those proceedings down in the description of the video. This is going to be his last appearance. And from what I understand, his brother is finally going to appear and take the stand. So I'm excited to see how this goes and give my commentary on it. And with that being said, guys, let's jump into this proceeding.
Good morning. Good morning, Ron. Yeah.
Good morning, everyone.
Good morning.
All right. Are you ready on the motion for Michael McCreary?
Yep.
All right. The clerk can call the case.
2356485, the people of the state of Michigan versus Carnell Michael McCreary. Mr. McCreary is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3, weapons, firearms, possession by a felon. Count 4, weapons, ammunition, possession by a felon. Count 5, assault with a dangerous weapon, felonious assault. Count 6, 7, 8, 9, and 10, weapons, felony firearm. With the habitual offender fourth defense notice set for a preliminary examination today. Before the exam, there was a motion that was filed by Mr. McCreary to disqualify me from this case, and that is why Chief Judge Conoco is on Zoom to address that motion.
Okay. Appearances.
Edwin Sawaki, P54A2A, appearing on behalf of the people.
Carnell Michael McCreary, natural person, not a corporation, natural flesh and blood.
Okay. Thank you. Thank you for your appearances. The court did receive a motion to disqualify Judge Elias Sabri pursuant to MCR 2.003. The court, having considered the pleading and being otherwise fully advised on the premises, the defendant having moved to disqualify Judge Sabri, but having stated no grounds that meet the legal basis under MCR 2.003 that would demonstrate that the judge has shown actual bias against the defendant or defendant's attorney. It is ordered that the motion to disqualify Judge Sabri is denied. This order does not resolve all pending claims as to the remaining parties and does not close this case. So the motion is denied. Thank you very much.
And Attorney Washington, I know you want to put your appearance.
Oh yeah, I'm sorry. Yes, Earl Washington as the backup attorney.
May I speak, Judge?
That matter.
Now that matter is resolved now. The court is turned over back to, excuse me, sir. The motion was denied. And now the court is being turned back over to Judge Sabri to handle the preliminary examination. Thank you very much.
Well, can I at least place my objections on the record?
It's been noted.
I mean, I'm just saying
Mr.
because
McCreary,
I thought you were the chief.
Mr. McCreary, your objection has been noted.
May I address the court?
Not on that matter. I can't hear a motion to disqualify. According to Michigan Court Rule 2.003, the chief judge has to address it in a
But that's not how the rule.
multiple judge court. This is a multiple judge court. Chief Judge Bucanico just addressed it. You received your motion in writing and he responded on the record and he denied it. There could be no more discussion for me about the disqualification motion, Mr. McCreary. It's been denied.
But can I just address something? I mean,
It's already been addressed in your pleadings and I cannot respond. I don't know if you understand. I can't respond regarding the disqualification.
I'm not trying to do that. What I was saying per the rule, under
Well,
due process.
You're still talking about something that has nothing
Well, I
to do with.
object and it's on the record.
Yes, and I've noted that. So as far as the exam, the time is now 10:17. Are you ready to move forward with your preliminary examination?
I came here today with intent, like.
Yes or no?
No, I'm not prepared because of this. I mean, I would like, you won't let me speak, Judge. Like,
I
you give
let
him
you
a fair
speak in
chance
regards to what
to
I'm asking.
respond, but you won't give me a fair chance to say or speak.
Mr.
I mean,
McCreary,
this
I
is-
let you stand here for 45 minutes last time we were here talking to you, didn't have anything else to say. So today I'm asking you, are you ready to move forward with your exam?
No, I'm not. I would like to call
Based-
witnesses and
Based on
subpoena.
what?
Pardon?
Based on what?
Because my intent as today, this motion was filed, the court was supposed to deny it because I thought you were the chief judge pro temp. And per the motion, it says that if you were the chief judge pro temp, it's supposed to go to the state court administrator. This gentleman here, I'm not familiar. Like first, the
You're
way the
still
rule-
addressing the motion to disqualify.
my due process is being
And
violated, Judge.
it's not.
I mean,
Because if
you won't let me
read-
tell you
It seems
why.
as if you can read it right. The court rules are very clear about motion to disqualify. There's it's black and white.
But what I'm-
So, Mr. McCreary has been denied.
Okay, we
And
understand
if
that.
you knew that, it also says that there's the timing in which the court can address that can be any time. So you knew you need to move forward with your exam today.
Well, what I'm saying is
So-
I have a right under 6.110 to call witnesses,
Yes, you
things of that
do.
nature.
And why aren't you prepared today?
Because you won't let me speak.
I
Your
didn't,
Honor.
no, I said, why aren't
I'm
you
trying
prepared
to,
today?
I'm trying to tell you.
Today's your exam date.
Can I respond? You keep cutting me off, Judge.
You're not answering my question.
I'm not prepared because when I filed this court was supposed to make a ruling. Then if you denied it, it was supposed to go to the chief judge.
No,
That is
I
due
can
process.
tell you no. It's not.
That's why I'm not
I can't deny a motion to disqualify in a multiple judge court.
Can I pull up the
Read the
rule?
court rules,
Can I-
2.003.
I'm familiar with it very well.
We're not that
In
familiar.
Crampton versus Michigan Department of State,
You
said
can
even if
say
you
any
can't
case
show
law you
bias.
want in a multiple judge court. I cannot handle your motion that you filed. It goes to the chief judge. Chief judge, I am chief judge pro temp, two different things. I cannot handle my own motion to disqualify. That would be bias, Mr. McCreary. So do you have witnesses to be there?
You won't let me respond.
Yes or
Judge.
no?
No, I don't.
Okay.
Because my intentions, as I stated, under
It's
this
just a
rule,
yes or no. I just want to know.
I
So you
mean-
can finish looking under court rule 2.0.
why am I not being allowed to address the court and give it a fair exchange like
I'm
the
asking you
prosecutor's office?
questions. This is not your courtroom. I'm
I'm
asking
not
you.
trying to
I
disrespect
have
this court.
given you
Judge.
all the leeway up until this point.
I mean, the law
Today's
gives
the
me
exam
rights.
date. Go ahead and check your court rules. Get back to me. Are the people ready to proceed?
People are ready to proceed, Your Honor.
And I object, I'm not ready. Because, I mean, I would like to address the record for preservation rights. So far as I have to go to the
Do you
higher
want to
court.
research 2.003 first? Because that seems to be what you were stuck on. Maybe, I want you to go ahead and
I
find
mean,
that
there's
first.
Michigan case laws, but Judge.
Court rule 2.003. Go ahead and find it. Tell me where it says that I'm supposed to address it.
Okay, section B, who may raise, the party may raise the issue of a judge's disqualification by motion, or the judge may raise it, C, disqualification of judge is warranted for reasons that include but are not limited to the following. The judge is biased or prejudiced for or against a party or an attorney. B, the judge based on an objective and
Those are the
reasonable.
grounds. You gotta get to procedure.
All right.
Section B.
Oh, my goodness.
Three. A. Start there. I can read it for you. 2.003 D3 under ruling.
I mean, I was getting down
One,
here.
in
You
a
say
court having
B3?
2 or more judges, on the request of a party, the challenged judge shall refer the motion to the chief judge, who shall decide the motion to no. That's what happened. It's a written order that will be provided to you stating the time. So, Mr. McCreary, I am ready to move forward with the people's witnesses.
Well, I have, evidence, I mean, since you're forcing compelling, which violates my rights under UCC 1-3. Wait, also, I'd like to make a non-pro time. Again, motion to, challenge the jurisdiction of the court. After this, the hearing we had last, I believe it was the 30th, I believe it was. The prosecutor gave me 15 pages, and he attested on the record, this is 15 pages all they had. There's no warning, there's no signature signing off for the, prosecutor to initiate charges, whatever else. I mean, this whole case, I object to this case being, moved forward under Brady violation, Fourth Amendment violation. I mean, they're committing crimes here in this courtroom, and this judge, you're allowing this.
Nothing has been presented to me.
I mean, I'm just saying.
I'm talking. Stop talking over me. You've been doing this since you've been in this courtroom. Every time you talk, I let you finish, whether it means it's meritless or not. I haven't heard anything of any substance or any value worth me addressing when it comes to Brady violations. So I'm ready to move forward. And if you want to call witnesses, and we have to hold in part because you didn't subpoena them today, we'll address that when it comes time after the people rest. So, Attorney Washington, is there anything you'd like to put on the record before we begin?
No, Your Honor.
Okay. Any preliminary matters from either side regarding the exam?
Preliminary matters, yes.
People have to address the court first.
Yes, Your Honor. People have exhibit 1, which I will show to the defendant and his Mr. Washington here. It is a register of action certified, case number 98007-861-01-FH. It indicates that defendant, Mr. McCreary, pled no contendere, assault with intent to maim, would like this as people's exhibit 1.
Oh, you say, I was found guilty. Assault with intent to maim. Hold on, he said I was convicted of that?
Under what court, under what statute?
Oh, I'm sorry, Your Honor.
I object, I wasn't convicted.
MCL 766 11B 1B.
I object to that, Judge. I was not convicted of that. Matter of fact, Judge Dalton Robeson was a visiting court. And again, this gentleman is lying to the court. He just lied to the court. That's perfect.
And you had the opportunity to review the document?
Well, he said that I was convicted of assault with intent to maim. Can I ask that what you said?
I said, you pled no.
No. I wasn't found.
Mr. McCreary, you review the document first?
Yeah. Okay, well, what does this got to do with the case? Robbery not armed, and assault with intent to maim. I have the transcripts at home. And the court order from Judge, he was a visiting Judge Dalton Robeson. Matter of fact, in that case, Your Honor, the prosecutor, what was this, Thomas Beadle, I believe his name was, he said that the officer in this case lost his entire file.
Can I see the?
And I have this transcript at home. How you gonna speak on something you lost a file? This case was the felonies was it was a misdemeanor, aggravated assault. And that's the case that, because in the transcript that I have at home, I would like to make that in evidence after this is concluded or whenever I can. Because he's just lied to this court, Your Honor. That's perjury committed in court, Your Honor.
Okay, I have a seal here from the register of action sealed from the Wayne County Clerk's office stating that you pled no contest to
That's inaccurate.
assault with intent to maim.
That's inaccurate, Your Honor. I had a transcript at home.
If you let me finish what I have to say, please. The jury trial was held. front of Judge Roberson. Sentenced and committed to Wayne County Jail. Your sentencing on September 8th, 2000. That's it. So for exam purposes, under MCL 766.11B1B, exam purposes only. This satisfies with you can place your objection on the record.
Well, I would like to say, because in this case, and I have the transcripts at home, and I object because this man just lied to the court, because in this case, that Thomas Beadle was supposed to be the special prosecutor. They held me there for 2 years. And he stated on the record, there's no support for this case. The officer in charge lost the entire file. So how are you going to present a register of actions? That's not evidence, Your Honor. I have the evidence at home. And I would like to object to this, and I would ask that you hold it in contempt of court for committing perjury.
I'm going to hold you in contempt of court in a minute. So I'm going to admit as Exhibit 1 over the objection of defense as a certified copy from the clerk's office for exam purposes only, showing that Mr. McCree was convicted of felon intent to maim in 2000. Anything else for preliminary matters?
Not from the people, Your Honor.
Okay.
Also, Judge, I would like to make a motion to sequester, because my intention is to call the chief
Sure.
detective on the stand, because.
Okay. You don't have to tell me a theory. I will do it.
Okay.
So let me do that first. So if there's a potential witnesses on this case, now's your time to log off. As far as in the courtroom, if there's anyone present who may testify on this case, maybe a witness, now's your time to exit the courtroom. What's next?
Per the court rule, I'm allowed to admit evidence for evidentiary purpose of impeachment under People versus Stanaway. I also would like to address to the court, Kim Worthy, last year, put a witness list out for officers who have previously testified falsely in court proceedings, that they couldn't testify in future proceedings. My brother, Norman McCreary, has committed perjury in front of Chief Judge, Wayne County Chief Judge Freddie G. Burton. He committed forgery, as well as identity theft. Also, I have affidavits from my other brothers where they've been trying to press charges. I tried to press charges, and the prosecutor them not doing anything. Also,
can I address that first?
Yeah.
So, Mr. McCray, if your brother testifies, you can definitely cross-examine him, impeach him, and bring all of that out. And if the prosecutor objects, we'll address it then. But you can do that on purpose.
I need to get y'all copies.
No, I don't receive copies until you introduce it and it's provided to the court. I don't do any preliminary impeachment. So once you cross him, if it comes out that he was convicted of a certain crime under the court rules or under evidence that allows you to discuss it, then that's your right to do so. Next.
I would just like, he was not convicted, but he was in the courtroom. It was established by the Chief Judge Freddie G. Burton. And my other brothers were kept in the line all these years, and they're trying to come forward. And I have an affidavit on my phone from my brother that's notarized. He's in the state of Florida. And
the brother that's testifying today?
No, my brother Charles had 5.
So you have to address your brother today when you cross-examine, okay?
Also, again, I would like to renew my motion to have the prosecutor's office withdrawn because of criminal misconduct, conflict of interest. My former attorney works for Kim Worthy as the director of the wrongful convictions unit, Valerie Newman, and it is quite well documented that Kim Worthy, as well as my former attorney, committed felonies. And it's all a matter of public record. And, you know, for this gentleman here to come here and try to mislead the court, I believe it's under 3.3 of the Michigan Rules of Professional Conduct. It states once an attorney knows, I believe it is, that they have told the court something, they must correct it. And this prosecutor is committing misconduct because I have from a stenographer transcript at home, in which I would like to.
You know the avenue to do that. If you want to report misconduct, you already know that. So let's get started with the exam. I've heard all of your motions and you place it on the record, and you will of course order the transcript to be able to move forward to the next step that you want to do. So any other preliminary matters to address regarding the exam today?
Well, how about, I'm just saying this, the recusal aspect.
No, I'm going to deny that.
Well, can I place my objection?
Absolutely. I hear your objection. Everyone else does. Ready to call your first witness?
Yes, I am, Your Honor.
Mr. McCreary, do you want to sit at the table up here?
I would ask that police officer be called first because we have to establish how he investigated and other things of that nature.
Now that would be you working for the prosecutor's office. You don't get to tell them how to try their
No, I'm
case.
not saying that. What I'm saying is I want to question that investigation.
Okay, and if the prosecutor, are you going to address their request? Or call who you said you're gonna call?
I have one witness.
Okay. So in this case, he gets to
Well,
start with
can I
however he wants
call
to.
as a witness? Being that he's trying to bring my brother, I would like to
So
establish.
procedurally, prosecutor has the burden of proof. You should know that. So
Well,
they have to go first. They have the burden here.
well, they have no
And then
evidence,
you
Your
can
Honor.
call
further.
witnesses if you like to. If
Yeah.
you feel necessary, you can do that. We'll discuss that after the legal rest, okay?
Yeah, they have no evidence, Judge.
You don't know what they have.
They just said it's in the paperwork.
I would like you to stay focused, okay? And the first thing we're gonna do is hear testimony from the people's first witness. That they have a record. So please, call your record.
People call Norman McCrary.
Remain standing, raise your hand. Raise your right hand. Once you sit down, that microphone, when you're talking, you can put that in your lap. Okay, Mr. Sawaki, whenever you are ready.
Sir, could you state your name for the record, please?
Norman Leon McCrary.
And what brings you to court today?
The incident that happened on the 9th, and I was leaving the house after another incident that happened inside of the house,
Okay,
and I went to my next door neighbors.
okay. Let me back you up a little bit there. Was that February 9th this year?
Yes.
Yes, and did that,
Objection leading.
Piece of paper.
No, I have some. Objection, he's leading the witness, Your Honor,
I think, sorry. go ahead.
because he said no.
one witness testified that it was night, I was merely, clearing up the accident, which the 9th of the month it was. or which month it
Objection,
was.
it's still leading.
Okay, this is, I'm gonna overrule on that because of the preliminary matters as far as date and time, and we did date night, and I believe this is clarification, not to be. So go ahead and get your-
Was February 9th, correct, of this year?
Yeah.
Okay, and then, what address did that occur?
14739 Homer, Detroit, Michigan.
And, that's in the county. of Wayne.
Yes, I
Because all the CEOs work together.
Now, you had, confrontation, right?
Yes, if that's what you want, yes, a confrontation, we talked after
Okay. Who did you have a confrontation?
Colonel McCrary sitting right there.
Could you,
Objection, Your Honor, I would like to also, there was a one single photo lineup, which he seen my picture prior to this exam, it was a photo lineup, single. And this is how, you know what I mean, he's my brother, true, there's a procedure on the due process.
Stand up for you.
Oh, okay, yes, I
I
would
know you
like.
have back issues, right?
I mean, I'm good, but I would like to object because there was a suggested photo lineup used. If you look at this discovery, it says that a single photo was shown to Mr. McCrary. And this violates, what is it, United States versus Wade, I believe it is.
It would be ways to address that. However, Mr. McCree, that's fine. It's very delicate for you to represent yourself. Because You just stated that he's your brother.
I mean, but it's
So-
still a procedure, Your Honor, that has to be followed.
I mean, this is one of the most easiest identification cases. If he knows you as your brother, he can identify you from that day.
But it's still, it's suggestion, it violates the law, Your Honor.
We're not even getting into the line at this point.
Well, I'll place my objection.
I hear you. So, Mr. Walker, please continue with your questioning.
Could you describe a piece of clothing that the gentleman,
He has a blue jean jacket that I had.
you know, let the record reflect that witness has identified the defendant?
It's not reflected.
What, at this address, you arrived at it, you had a confrontation. Could you go more into that?
Well, prior to, seeing, my brother Carnell, I had went into the house the day before on the 8th. And, the downstairs door, which is the part that I had, was kicked in and damaged. So, and then I went into the back room and the second door was kicked in and damaged. Objection, Your Honor, he just committed perjury. The first door is not kicked in and he speaks of.
Sir,
Oh, okay, I'm sorry, I didn't know I had to say it, I'm sorry.
what you're doing is you're testifying as to what happened. All you can do in this case, if you're saying that he's not telling the truth, is on cross-examination, you have opportunity to question him and possibly raise issues of credibility. But at this time, you're testifying as to what happened and not an objection regarding the rule of evidence, okay? And every objection has been placed.
I understand this, man. And if I may finish, though, and upon going into the kitchen.
Hold. Second. Describe this house. Is there like, is it apartment?
It's an income bungalow. So it's an upstairs and a downstairs, and they're separate, and they both have separate utilities. And the downstairs is the part of the domicile that, I was, having, I became the executor of this estate. So, I kept the house so that my other siblings, including him, could stay there.
Okay.
So I came downstairs.
Say no, who are you referring to?
Cornell McCreary. So when I came downstairs,
Just so the record's clear, whose estate are you talking about?
my deceased mother's estate, name McCreary.
Who lived up? Did someone live up in the?
Cornell McCreary stayed upstairs after he was released from prison.
Okay. So you came in and there was damage?
Yes, there was damage to the front door, the kitchen door, and a bedroom door.
Okay. What happened?
Okay, so
And this is on the 8th.
yeah, so I didn't have a camera with me at that time to take pictures of the damaged property. So I came back on the 9th, and then once I came back on the 9th, I took pictures of the damages that were, incurred in, the house.
What, after you took your pictures, what did you do next?
I left the house and then I went next door to one of our neighbors she had fell sick and she had a pacemaker. So, she grew up, we grew up with her. She's like a mother.
Okay.
So I went next door and, visited her. And then upon leaving, when I was coming out, my brother was coming, Cornell.
Okay, you were coming out of the neighbor's house. Where was your brother coming out?
He was coming out of 1417 home.
Okay, and that's where he lives. Correct.
He lives in the income bungalow upstairs.
Okay. What happened when you got it?
He confronted me and, I told her, I said, so is this how you're gonna do our mother's house? And he was, he started talking about taxes, which he hasn't paid, So, and then I was like, and I tried to ignore him. So he's like, so you going to go to the police on me and all this kind of stuff. So, and, I was like, yeah, I'm going to the police. And he's like, well, somebody's gonna die today, me, you, or the police.
Okay.
So, and then ignored him, and I went to my automobile,
Okay.
and I was about to get into an automobile. He picked up.
When you got into your automobile, what happened next?
He picked the brick up and hit the car with the brick.
Okay.
So I jumped out of the automobile and, ran after him, and he ran. So, I was like, man.
Okay. Where did he run?
He ran up on the porch of 147 down.
Okay. You sit tight, Your Honor. When he ran up, when he's on the porch, what did you do?
I went, I ignored him and went back to the car because I was going to go out of police.
Okay. And when you went back to your car, what happened next?
He picked the brick up again and hit the car again. So now this time I ran after him again, and he ran up onto the porch, opened the door, and then came outside with a semi-automatic weapon and fired into the air twice.
Okay. He fired it twice.
Yes.
And then what did he do?
And then
I'm sorry, did you say into the air?
yes, into the air twice. And then he looked at me in the eyes and then pointed the weapon at me and shot in my direction. And,
Okay. When he shot in your direction, where did the bullet go?
it's a field right across the street from the house. So I can't say where it went, but it went in that direction towards the field.
Well, what did that do to you as far as?
I was, first of all, I was upset that my brother would do something of that nature. Then, I kind of feared for my life, so I jumped into the vehicle and drove off.
And you said the weapon was, what type of weapon again?
It looks like it was a rifle. It was a black. It could have been an AK.
But you're not sure, right?
No, I'm not sure.
Okay. And after you got in your car,
I was really upset. I went directly to the precinct and I filed a report.
okay.
And
I have nothing further for this witness at this time, Your Honor.
Ross, did I make it?
yes, I mean,
And Mr. McCreary, and just want to let you know, you are bound by the rules letter. If the prosecutor objects, if you need any help with it, Mr. Washington is there for you. Okay?
how you doing there, Norman McCreary? I'm here. You all right today? Okay. Let me direct you. You stated that I shot in the air. Is that correct? That's correct. Okay. Isn't it also correct that you said I shot in the ground as well? I didn't see you shooting the ground. Well, no, I'm just saying, is it just a no? Did you say I shot in the ground? I didn't see you shooting at the ground. Okay. Your Honor, yes or no? I would like to reflect for the record that at another proceeding, the prosecutor stated that he said that I shot the ground, shot in the air, and shot him in 3 stories. Okay.
Your Honor, I don't recall that, and
This
today
was
we have
a-
to go by testimony of the witness. That's what we're here.
Well, you were the spokesman for it, sir.
I represent the people, sir.
Okay, that's all right. Okay, you spoke about a probate issue, am I correct, that you were the executive, sir? Yes, I did. Okay, isn't it true, have you ever committed perjury, or have you ever committed forgery or anything that nature? Oh, Your Honor, you just lied. Here's the paperwork, this impeachment with, isn't it true that you forged, my name? What does this have to do with, well, it's impeachment, sir? It's impeachment, sir, people versus Sandway laws, the rules of evidence. Isn't it true that you forged my name, David McCreary, Norman McCreary, Paul McCreary, James McCreary, and Charles McCreary? That is not true. Okay, I have affidavits from him notarized where he stated that the brothers gave him permission to sign individuals' names, and the judge issued a show cause hearing. Give me a second, please. Okay, here we go. Here's an affidavit I would like to get a copy of to the prosecutor's office. It's signed and notarized by Norman McCreary. And this is allowed for impeachment purposes. He just committed perjury on the stand, Judge. And on page 2, Norman said that the other brothers, Charles, James, and Paul McCree, agreed to getting the loan, the signing of their names. Oh, okay, yes. Could you, I'd like to give it to your witness and see it too. You just lied on those, sir. And it's signed and notarized by him in the Wayne County probate proceeding. That was forged by the judge. It was not, and I had to follow the judge. He committed perjury. And I have an affidavit from my brother on the phone too, that he didn't give me permission as well. And I'd like to have, that's why I was saying about witness call judge.
F1.
Your Honor, this is just an affidavit. It doesn't show anything about perjury. And not only that, but
It's forgery, sir.
1 second, Mr. McCree, one at a time.
in order, the court rule, in order to be impeached, it has to be conviction. Therefore, I'm gonna object to this line of questioning unless the defendant can show that the witness was actually convicted.
Where is that case law? Show me the authority by that, that's why.
The court rule.
The Michigan rules of evidence
Judge,
allow for.
He just
impeachment.
lied
Mr.
under oath,
McCree,
and he lied under oath in the courtroom.
Court,
That's
you,
why I don't like this
Mr.
subpoena.
McCree, let me finish addressing the objection. Under the Michigan rules of evidence, to attack someone's credibility and to impeach them, you have to do it under whether or not the witness has been convicted of a crime involving dishonesty, false statement, or theft. If there's no proof of a conviction, I'm not sure how you plan on proving that with an affidavit that has not been verified by anyone, no court other than an affidavit signed by another person who's not here to testify.
This is affidavit. This is what I'm saying, it's signed and notarized, Judge. And then I was also previously, I had transferred by police officers in Wayne County from complaints about them, and the judge allowed it. I just asked him, did he ever forge anybody's names, whatever else?
He said no.
And he said no. And the affidavit shows that he said my other brothers agreed. I have affidavits from Charles McCree and other people that say they didn't give him permission. This is a felony. This is a crime, Judge. How can you allow this gentleman to come in here?
Mr. McCree, you have to file a police report for that crime.
I tried to.
Well, I can't.
They ignore, they're vindictive to second prosecution, Your Honor.
I'm not allowing you to present an affidavit. There's no conviction of the 3 things, dishonesty, falsehood.
Okay, can you show me in the rules of evidence where that is? It says about conviction, because other courts, I remember, I can't think of the chief judge from '99, he was here, he allowed.
1999.
Yes, Capers P. Harper was my attorney at the time. There was a deputy sheriff named Clifton Needed. And we asked for additional discovery to impeach him. And the judge allowed it at the time. I have this document at home as well. This is for purposes of impeachment. He just lied and said he never forged nobody's signature. And that doesn't equate to conviction or not. I have affidavits saying that, yes, he forged my signature, he committed felonies, and he did what he did. And this is his affidavit of truth.
Saying that he committed felonies?
It shows that he said.
Yes or no? Does it say he committed felonies?
Yeah, right here. It says that Charles and them agreed for him to sign their names. My brother has an affidavit saying that he did.
That's not saying I committed felonies.
Forgery is a felony.
I know it is. So
Identity
is lying,
theft
so is shooting
and
people,
perjury.
so telling people you're gonna kill them, so is murder. There are a lot of crimes.
So that's discrimination on your part
If it
because you're
hasn't been
allowing
proven
me
or
saying.
established, then what do you expect me to do?
Well, I have the affidavit showing this contradicting what he's saying per my witness,
For the rules of
Charles
evidence?
McCrary. And I would like to admit that in evidence as well. Because he's saying that he didn't forge these people's names and my other brother's saying that he did. And this for purpose.
Michigan rules of evidence.
And can you give me the rules?
609.
609, okay.
609.
Go here. You just lied under oath this time. MRE 609.
For purposes of attacking the credibility of a witness, evidence that the witness has been convicted of a crime shall not be admitted unless the evidence has been elicited from the witness or established by the public record finished during cross-examination and the crime contained an element of dishonesty or false statement, or the crime contained an element of theft, and the crime was punishable by imprisonment in excess of 1 year or death under the law under which the witness was convicted. So the issue here is that there was no conviction. So
Okay,
I'm not admitting that evidence.
can I
Move on to the next question.
give you, speak about the rule?
I'm denying objection. This place that you, disagree and object to my sustaining the objection.
Yes, I do object, and this goes also, again, I would like to renew my motion to recuse under People versus Crampton, Michigan Department of State, Crampton versus Michigan Department of State, Kane versus MDOC, because this court is being biased, and there's previous proceedings where the court allowed these types. Yeah, under, in this court, in
I didn't
99.
do that.
Well, what I'm saying is I asked him a question. He said, no, I have evidence to show he did.
I have the evidence under
And it
Rules of
involves-
Evidence 609 that allow for you to establish that. Next question, Mr. McCray.
Okay, now here you just spoke on the rule, and I would like to argue the rule. It says unless solicited, I solicited from him and then dealt with theft and dishonest crime. And this court, I feel, is being biased toward the prosecutor.
You're sounding like a broken record. I heard you already.
All right.
Denied.
Okay. Can I continue? And I object again.
Please.
Mr. McCurry, isn't it true that you consider yourself a sovereign citizen?
Does that have to do with this case?
Well, it's relevant. It's relevant.
Yeah.
Goes for credibility impeachments, Your Honor.
I object to the relevancy of the question.
It goes to the credibility of the witness and to test his credibility.
So sovereign.
People versus
sovereign-
down. People
Mr.
versus
McCray,
down.
the case law, you can stop right now. Rules of evidence. How is this relevant to the case here today, whether he's a sovereign citizen? And don't say anything about dishonesty, because you are too, and you've
How am
established
I
that.
being dishonest?
I said, don't say that it's about dishonesty, because you've stated that you're a sovereign as well.
I mean, yeah, I agree.
So
I'm
what
not,
is the
I'm not, I'm
relevance
not the
of
straw
him being a
man.
sovereign today
I'm
while
not,
he's
I'm
testifying?
not the straw man. What I'm saying is,
Answer the question. How is it relevant that he's a sovereign citizen?
because he's the same person that fights you guys. In court, he's issued,
I'm
affidavits,
indigenous to this land, what you should answer.
Both of you all, in a minute, in this exam, there's gonna be some contempt hearings going on, if you all don't stop. I don't care if he's a sovereign citizen or not, that has nothing to do with the case here today. So I don't find it to be relevant. So next question.
So you stated that I shot in the ear, is that correct?
Yes,
Okay, you also stated that I shot at you as well.
yes.
Okay, is there any witnesses to this? And what time was this about?
Well, I can't remember this young man's name, but him and his mother was outside.
Okay, so what time was this?
I can't remember.
Can't recall. Does the people have this information, Judge, if he doesn't know the time that this occurred? Because on this day, I was at work.
It was
I
after
was at
work.
work in Oak Park.
It was around probably after 5.
You just said you didn't know, Mr.
Well,
Burns.
I said I don't remember, but if I try to recollect, then I would say I get off work at 4:30, so it had to be after 5.
Okay, are you familiar, do you recall that I worked at Glory Supermarket in Oak Park?
I don't know, I didn't know where you were. You barely
Okay,
worked.
now let me ask you this, for your birthday, didn't I get you 2 bottles of rosé for your birthday? And I told you about I got a cheap.
Objection.
Well, no, I'm trying to establish that he knows that where I worked at. This is what
I knew
I'm
that
trying
you
to
had
establish.
got a job, but yes, you
At a
did.
supermarket.
Yes, you
Okay.
did.
To the McCreary's. There's an objection on the floor. Everyone has to stop talking.
Thank you.
For a couple reasons. The court reporter, you are torturing her right now because she cannot take down anything when everyone's talking. So please, one at a time. There's an objection on either side. Stop talking. So there's an objection. What is your objection?
Relevancy.
What is the relevance of the 2 bottles of
Well,
rosé?
to establish that he knew where I worked at, so that I can let it be known that I was at work during this time that he claims whatever this stuff is going on.
Okay, even if he doesn't know where you worked on that day and time.
Okay, that's
It's
what I'm
not
trying to.
relevant to the day and time in which you were at work.
Well, the time of the crime that he stated. I mean, if how do you not know what time the crime was committed? You saying the date, but what time?
We're talking about you were to work, where you worked, or the time. of
Well,
day.
what I'm
Because he
trying
said
to.
it after 5. It had to be after 5 if he works until 4:30. He doesn't know the exact time. Is that my understanding of what he said? Is that correct?
Well, I worked afternoon.
Is that correct? What he just said?
Pardon?
He said after 5 because he just don't work at 4:30. Not sure what time, but somewhere after 4:30, after 5. Is that correct?
I mean, this is what he stated.
That's all I want you to say. We all agree on what was said. Okay, so he doesn't know the exact time. I understand. Next question is, how is the 2 bottles of rosé relevant to the day of the
Well,
event?
the reason that I stated that, Judge, is because he knew where I was. I was telling him about how cheap things were there with my employee discount. So he just stated he didn't know where I work, but he knows where I work.
Okay.
Because I gave him 2
So-
articles from the job for his birthday.
Okay,
And then, I have witnesses, that I would like to call in, Robert Van Dyner,
okay, you
Gerald
can call that
Flowers,
when
and
it's
other
time.
people.
Oh, it's-
Yes, because Mr. McCreary, was paid money. This is why, He's-
Mr. McCreary.
okay.
Last
All right,
question
let me-
for
let me- okay.
examination.
Mr. McCreary, isn't it true that you allowed Mr. Robert Van Dyner and Gerald Flowers to rent the downstairs at some
I'm
point?
gonna object to relevancy.
Well, I'm trying to establish, that Mr. McCreary is committing crimes, past and present. This is what this is about for purposes of impeachment.
No, for impeachment, you have, I read the rule, 609. Unless you have some other route, you asking questions about,
Well, the thing is, he's stealing money. If you look at the taxes, like the taxes is still in my
and
mind.
guess what?
After
Even
10 years,
if
20
he
years.
was stealing money, it wouldn't be relevant today during this testimony.
So he can steal from me and that's okay. And other people, it's okay.
No, it's not okay.
And I've made reports, and the 10th precinct is retaliating because I made reports against their officials down there for failure to protect.
You are
Judge.
muddying the water, not staying focused on what has been charged on this case.
Well, I'm being denied my rights. This is what I.
So I am going to sustain the objection, it's not relevant. Question.
Okay, isn't it true, Norman McCurry, that, the taxes mainly McCurry are still in her name after 20 years of being the city servant?
Yeah.
No, it's this, your witnesses committed felonies and you're committing felonies with them, you and Kim work.
Okay.
And there is documented, I'm just, this purpose of
It's just,
impeachment.
well,
The purpose of impeachment.
Okay. okay, next question.
May I ask you a question? How did you come to, work, here to court? How did you get here? Did you drive or were you brought?
Objection, Your Honor, relevancy.
Relevancy is Mr. McCurry is driving, he has no license. And
Okay,
he's
are you
breaking-
just trying to
he's breaking-
tattletale on him for
No,
everything
I'm
he does all
impeaching,
day?
he's breaking laws, but I'm being accused, I'm innocent.
Okay,
I'm innocent,
it's still not
Judge.
relevant to the allegations and to what he testified to on direct examination.
Well, if I may respond, the relevancy is that Kim Worthy has executed things against police officers, but the witnesses are being allowed to commit perjury and get on the stand. This violates the officer's right, equal protection clause of the 14th Amendment. Because if officers have testified or lied and they weren't convicted,
What does the officer have to do with anything right now?
well, this is the witness.
He's not an officer.
He's a witness though. It's just,
It's
if
not
you
the
look.
same. This was a very specific case. We have specific testimony. I don't care if he has a license or not. So sustained.
Well, what I'm saying is,
I don't care if he has a license or not.
well, the police and him, they're being allowed to commit felonies, but I'm here to be accused. And this is,
You
I'm
have
trying
been
to
accused.
establish,
You're not being accused. You have it.
okay, I'm being accused. I have been accused, yes,
Next
and there's
question.
no evidence. Mr. McCurry, can I ask you a question? Did you know that there is no evidence in this case?
Objection.
Why?
How would he, he's not an officer.
Well, I'm just saying, there's no evidence.
And actually, there is evidence.
Where is this here?
Your Honor, his testimony is evidence.
That's not
That's the
evidence under Opera versus United States.
Under the Michigan rules of evidence, testimony is evidence.
Oh,
Next question.
okay, may I object under Opera versus United States, testimony without cooperative evidence is not evidence.
Yeah,
Jackson
so
versus Virginia,
That
and wait.
is incorrect. Next question.
I just say I'm being lynched today. by this court as well as my brother.
Is this your closing argument? Because you can say that.
Well, I mean, you won't let me bring nothing in. You're shooting down everything that I brought in because of judicial bias.
It's not
Well, other courts have
accurate
called
under
it
the
relevant.
Michigan court rules of evidence, under the Michigan court rules, under the rules of evidence. So I'm not lynching you. I'm denying you certain things that you're doing because it's not applicable and proper in court.
All right, now may I respond to the rules of evidence, statement that you
No,
made,
you can
Judge?
ask the next question that's relevant to the exam you're taking.
Well, I mean, I can't ask everything. You shoot down everything I bring it, Judge, and I
If you don't have
object.
any more questions on cross, then you can say no more questions. Have a seat. If you don't have anything
I'm
that's
being
relevant
denied.
to the direct evidence that was provided, or the testimony on direct.
Well, may I address something that you stated, Judge, if I may?
Question to the witness.
I mean, I just yield because I'm being denied my rights, and I object to this whole proceeding because I'm denied to present evidence and call witnesses on my
No,
behalf.
you haven't been
To
denied.
properly
The people haven't
cross-examine,
requested for you to
to
even
properly
present
cross-examine the
any
witness, and then they're charged me with strangulation. It says injuries. No, this man is not hurt. He hasn't been shot. They got weapons and strangulation. I do all this to him and it's that wrong.
evidence.
This is what I'm
You
trying to
weren't- You weren't
understand.
charged with strangulation.
Yes, it's in here.
It says or by strangulation.
Okay, what the first part?
Assault with intent to create violence.
Okay, assault with intent to great bodily harm. He has not been hit. He hasn't been hurt. He hasn't been anything happened to him. Where's the medical
So
report?
get to that in the argument. Therapy. You'll learn the elements. of
I
that.
mean,
Know that.
I just object and I'll rest and I'll leave it to the circuit court as
But you
well
can't
as.
rest, you haven't even had an opportunity.
Well, I'm
to
just
present
saying
witness. Do you have any
because,
more questions of the witness?
I mean, I'm being denied my rights
Yes,
to properly
or no?
cross-examine.
Do you have any more questions of the
Oh,
witness?
no, because I'm denied the
Okay.
right to proper cross-examine.
Any redirect?
No redirect, Your Honor.
Unfortunately, guys, we're going to have to stop this proceeding right here because from what it looks like, there is another 45 minutes left to this proceeding. We will share that on tomorrow, the conclusion of the proceeding, the conclusion of what happened in this case as well. But for now, this proceeding right here, that just transpired before our very eyes, man, a whole lot happened in this proceeding. As we can see, as soon as it started, we see Judge William C. McConaughey making a special appearance. Why? Because Mr. Carnell decides after his motions was denied in the last proceeding, and that's why we said those of us that have seen those, if you haven't seen them, to go see them because you'll understand what's going on. Because his motions were denied by Judge Sabree, he goes and tries to get her disqualified from the case. And as we can see, that was denied by Judge McConaughey. Then, obviously his brother finally comes to testify. He's constantly screaming about how his brother has committed perjury in the past on the stand. He can prove it. He talks about how his brother has forged he and his other brother's names in the past and spending his mom's money and doing stuff with the property. So from what Mr. Carnell is saying, it seems like Mr. Norman, his brother, has done some shady things as well, according to him, allegedly, right? But as we can see, the brothers, they go back and forth. He's telling other things. He asked the brother straight out, are you not also a sovereign citizen? You don't even have a license. He tells the judge, listen, my brother, he's driving around. Matter of fact, he asked his brother, did you drive here today? And the reason why he asked him and he wanted to let the judge know is because he doesn't have a license. So it seems like his brother also has his super sovereign citizen head on. And you heard his brother yell out a little bit of script himself. He was ready to go full script. And you hear the judge say, listen, what are you going to do? You're going to tattletale on everything that your brother has done. But yeah, this thing has gotten heated. It got heated to the point of where she was ready to hold everybody in contempt, both of them in contempt. But this has been a very wild case. His brother alleged that, listen, he hit my cars with bricks. You hit my car twice with a brick, shot in the air, and then shot past me. But then there was some controversy on some of the evidence and what was said in the past about shooting at the ground. So this is going to be very interesting to see how all this ends, because Mr. Carnell seems to be very confident in the evidence that he has, that he's trying to present, but it's not the time to present it because this is not the trial, right? So I don't know, guys. I think this is just going to definitely have a wild and crazy ending. From what I understand, I believe next there's going to be a police officer that's involved in this case, and Mr. Carnell is going to have the opportunity to cross-examine him as well. So I'm looking forward to that tomorrow. I know you guys are too. With that being said, we've been here long enough. Let me get out of the way. Once again, this is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. Thank you for joining me. Appreciate you guys. God bless.